much. Yes, the agenda is as follows. We have had the opening and welcome, but also we will take that issue further a little bit from now, but we will at some point therefore request the minister will explain why we have asked for this meeting. And then, of course, after that, the CRL Commission will have a discussion, and then we'll take it from there. Let's proceed, therefore, from this agenda. It's a very specific meeting. May I then just give the background for Minister 𝐿𝐵𝐵𝐿 so that we are together before the presentation is done. From our portfolio committee, I hope that Shireen, you can share all the documents that we have received so that all the members have got these documents. Honorable Minister, thanks very much for making time to talk to us. Why we requested the Minister to come and have a consultation with the committee is because the CRL as a structure actually is falling under the ministers under the Ministry of Cooperative Governance and Traditional Affairs. We understand how the reporting lines work, but we thought it would not be easy to proceed on this matter without a proper discussion with the minister. Now, the background to the issue is as follows. Way back in 2018, there were a number of concerns raised by the community that related to the abuse of, the religious platforms by various religious leaders. These included reports of sexual and other abuses, and some of the individuals were even taken to court. Then there were instances of concerns around people being made to ingest rodents, ingest fuel, to ingest. Some of them were made to eat grass and all of this, and some of them were cults where people were stopped from attending school. Children were stopped from attending school, and all of these were thought to be basically transgressions that have a human rights violation as a matter of concern. So the matter was discussed through and ultimately landed up with the CRL Commission discussing this matter with the portfolio committee, and after quite a bit of consultation, then there was ultimately a conclusion that certain steps had to be taken. Amongst those were a national consultative conference to discuss these issues and look at how these matters can be managed by the religious fraternity. In that process, the portfolio committee made a report which didn't quite make it to discussion at the level of the portfolio, at the level of Parliament, and therefore subsequently lapsed because of the expiry of the term. This is contained in one of the letters that the Speaker had actually sent to some of the people who raised the matter. In the meantime, the committee was looking at creating a Section 22 committee for purposes of looking into these kinds of challenges in the form of regulation. And a number of institutions or bodies were consulted, and in the process moved ahead with this idea of a Section 22 committee. In the course of all of this, a number of other bodies came up and objected to the process, mainly on a number of issues. Firstly, that they thought it was focusing on Christianity. It was also focusing on certain but not all, and therefore not an all-encompassing process. And of course, they argued that there was a regulation of the church by the state, which was impinging on the freedom of religion. So this has therefore been the debate that's been going on, with letters written to the president, to the speaker, to the minister, to the committee, and all of these have been sent through, have been shared through. If it was possible, we'll still make sure that you receive them if they've not all been circulated. Then in the process as well, then there was a march which subsequently had issues raised with various demands made onto it. And of course, as the chairperson on behalf of Parliament, I went to receive it, and then the committee discussed the matters. Our approach onto this matter was that we need to re-establish this matter as an active matter within the committee, seeing that we wouldn't be able to take the previous report as it had already lapsed, and so we needed to start this process for purposes of any further engagement. We need to actually establish it as a process. The members of the committee had raised various concerns about the approach of the CRL, and the others, of course, were wanting us to look at the various authorities, executive structures that would have been involved in this matter. We haven't got much yet from the president. We are going to report to the speaker, but we thought that the minister could also just give us his wisdom on the matter, and we've actually asked the CRL to give us this information from where the matter started, and then we can look at how well we can start the process going forward to address the concerns of those who have objected, and of course the issues that were raised to the CRL. I think that should give a kind of a background as to where we are, and we therefore felt that we should consult the minister, and then after that we hope to actually engage again with the CRL and also some of the bodies that were already consulted by the CRL and those that have already objected to the CRL process, and find a way of how this matter can be handled. Honourable Minister, that is the background that brought us to this meeting. May I therefore welcome you, Honourable Minister, and ask you to take us through. I note that there are some presentations, but of course this is going to be your meeting. We're going to lead us, and then we'll take it up from there. Thank you very much, Honourable Minister. You are on the floor.
Thank you very much, Honourable Chair, Dr. Mkhize, and greetings to the honourable members of the portfolio, the chairperson of the commission, and all the commissioners, the senior officials. Let me firstly, Chair, convey the apology of Deputy Minister Barnes Ngamashe. Honourable Chair, thank you for the opportunity to engage on this matter, which you have conveyed a background. And our response, Honourable Chair, on the matter, we prepared a presentation which will be led by DG Dipova, and then we can engage on the matter once that presentation has been done. We have had a meeting with the Commission last week, and we are still going to be having a follow-up meeting with the Commission the second week of December to iron out certain key issues that transpired in our meeting, but those matters do not affect the meeting that we're going to have, that we're having right now. With those few words, Honorable Chair, if you then allow us, we can give our perspective on the matter through the presentation that we prepared. And then we can find a common way as a common ground to take the process forward in the midst of all the complaints by certain groups in relation to Section 22 committee. Thank you very much, Chair.
Thank you very much. You're welcome, Honorable Minister. You may proceed with your presentations. Thank you.
Very good evening, Honorable Chairperson of the committee and honorable members of the committee, to the Honorable Minister, the Chairperson of the CRL Rights Commission and other commissioners present, officials and colleagues. Thank you very much for this opportunity, Honorable Chairperson. We've pulled together this presentation informed by the documents that we have received, engagements that have taken place with the CRL Rights Commission. We also had engagements with an organization called Freedom of Religion South Africa, for SA for short, which is one of those organizations that have raised concerns about the report of the CRL Rights Commission. So that meeting only took place yesterday. I will request the Honorable Chairperson, to your permission, that I switch off the video from here to save on bandwidth. So in the presentation, Honorable Chair, as we go to the introduction and background, there is quite a bit that the Honorable Chair has already touched on. So we are in possession of that memorandum from the South African Church Defenders, which is dated 13 November 2025, but we are also in possession of a document with a number of annexures from Freedom of Religion South Africa for SA, in addition to a meeting that they had asked for that we then had with them yesterday. Of course, that meeting was preceded by the meeting with the chairpersonship of the CRL Rights Commission that the Honourable Minister was referring to. The chairperson has already indicated in terms of the issues that are being raised, and we just indicate that by and large those issues are similar, except that with the church defenders, they conclude with specific demands, one of which is the removal of the CRL Rights Commission chairperson. However, the 4SA submission raises concerns but doesn't make demands at the end. It makes alternatives, proposes alternatives and makes proposals instead. Now, on the next slide, we just indicate that they relate obviously to the Section 22 committee of the CRL Rights Commission, and the concerns relate to what we are listing here, that there was lack of representation. We've seen from the memorandum from the church defenders that they say the committee is male dominated and it comprises hand-picked members by the chairperson. This is taken straight from their memorandum, that the committee has come up with what they regard as a draft white paper, and that this was preempting the process because it was generated even before proper consultations could be conducted, and of course that it's unconstitutional because there is no legal basis for the committee and the commission to be coming up with a draft white paper, as they call it. And on the next slide, we then just summarize those key issues. So the church defenders say that the recommendations are unconstitutional. They are unnecessary because they say other pieces of legislation that are there and other ways in which the concerns that the CRL Rights Commission seeks to address can be addressed. They are unjustified, they are unworkable, and they are unfair. Freedom of Religion South Africa says that the process has a predetermined legislative agenda, which means that the consultations that will follow are just a waste of time. They will be meaningless because it has a predetermined outcome. They say the process is also characterized as a doctrinal intrusion targeting Christianity first, and I think the chairperson also highlighted this issue. That is it's a revival of a previously rejected model, and they're basing this on the fact that the report was previously presented to the then portfolio committee. The portfolio committee made certain recommendations, which Freedom of Religion South Africa interpreted as a rejection of what the CRL Rights Commission was proposing. And then, of course, like South African church defenders, they say there's a false legal mandate here, that the Commission doesn't have a mandate to regulate the sector, that what they're coming up with is violating core rights, and the proposals are unaffordable in terms of implementation. Here we just link it to that 2018 report. The chairperson has spoken about this report already, so we'll not go through that again. But on the next slide, we just then reflect in terms of, if colleagues could just move to the next slide, please. The recommendations that the resolutions that the portfolio committee took at the time when the when the report was presented, the chair has already indicated, spoken about this, so I won't go through them, and the fact that they were not adopted before the end of the parliamentary term. But we just make that point in that last statement there at the end, that therefore the status of the recommendations seems to be contested, because if you look at the memorandums that we have spoken about, they believe that through what happened in 2018, those recommendations of the CRL Rights Commission were rejected. But of course, as we engage with the discussions and through what the chairperson has pointed out, there is an issue of expiry here that need to be looked into as well. We then looked at, in the next slide, we then looked at where the minister comes in. So the starting point was that it is, the CRL Rights Commission is a Chapter 9 institution established under the Constitution. We looked closely at sections 181, subsection 2 to subsection 5, which affirms their independence and accountability to the National Assembly, and section 181, subsection 4, in particular, that prohibits interference by any person or organ of state. But in addition to this, there is then the CRL Rights Commission Act, Act 19 of 2002. It designates a minister responsible for the administration of the Act. And so in terms of a gazette by the president, that minister, because the Act does not specify which minister, but there's a gazette by the president which then specifically says that minister is a minister of provincial and local government, who would have then been the predecessor, the Minister of Cooperative Governance and Traditional Affairs. But we looked at the roles in the Act. There are very specific roles that are contained in the Act in terms of what the minister's responsibilities are. So we've listed the main roles there. One is that the minister approves a policy framework for the Commission staff establishment and how the Commission disposes its asset. That the minister facilitates the appointment of commissioners. Ultimately, the commissioners are appointed by the president, but the process of recruitment and selection, call for nominations and so on, is the minister that is responsible for doing that. The minister is also responsible for determining conditions of service for the commissioners, but with the concurrence of the Minister of Finance. The minister is responsible for funding of the operations of the commission. So as matters stand now, the budget of the commission is part of the vote of traditional affairs. But the arrangement is that traditional affairs is simply a conduit which transfers the budget in tranches to the CRL Rights Commission. So on a quarterly basis, there will be a tranche that is transferred to the CRL Rights Commission. But it is made very clear that the role of the department is simply that of transferring, and reporting is directly to Parliament and not to the minister or to the department. Of course, there is also provision for the making of regulations, which means that out of the Act, if there are particular areas that need to be elaborated on for implementation through regulations, ultimately then the minister becomes the member of cabinet who becomes a conduit for making those regulations. So we then conclude, Honorable Chair, by saying, so what does this mean given what we are faced with at the moment? So the first point is that as the Commission is accountable to Parliament and not the Minister, it means that the Minister may not intervene in the Commission's operations unless there can be explicit legislation that enables the Minister to do so. So, for example, in terms of the manner in which the Commission conducts consultations, in terms of the texture of the recommendations that the Commission makes, in terms of the committees that the Commission appoints, the establishment of a Section 22 committee or the possible disbandment thereof, there isn't any enabling provisions legally for the Minister to do that. We also note the issue raised by the South African Church Defenders, their demand that the Minister that the chairperson of the Commission should be removed. And we indicate here that there is a provision in Section 17 of the CRL Rights Commission Act, which deals with circumstances under which the chairperson of the Commission may be removed. But that responsibility is assigned to the National Assembly as well, not necessarily to the Minister. So it means that the demand for the possible removal of the chairperson of the Commission, taking into consideration Section 17 of the CRL Rights Commission Act, may not be led by the Minister as well. So this is the interpretation that we have in the department, and in the last slide that concludes the discussion, just emphasizes that the Minister's role is limited to administrative support, administrative facilitation as defined by the law. However, if there is going to be any work that relates to policy development, legislative proposals, means that at a particular time, those proposals must then find a way through, once other processes of the Commission have been exhausted, find their way through the right protocols of legislative drafting in government, so that then the Minister can step in as a member of the executive assigned the responsibility of the administration of the Act. So, for example, if it becomes necessary for the CRL Rights Commission Act to be amended, there will then be a process that would require the Minister to lead that as the executive member of cabinet assigned the responsibility. If there have to be regulations that are developed to support the implementation of the Act, after proposals have been made and consultations according to the protocols of the CRL Rights Commission have been undertaken, there will be a stage where the Minister, as the member of cabinet designated by the Act, may have to step in. But other than that, the role is limited, as we indicate in the presentation. And that is the input, Honourable Chairperson. Thank you very much.
Thank you very much, Director General 𝐃𝐨𝐽, and thanks very much, Honorable Minister. I think for us, in trying to re-engage on this matter as a committee, it was important for us to have a consultation with the Minister. There are a number of issues that are involved in this matter. Certainly, as the line function minister, we need to, right from the beginning, establish our lines so that there is no overlap of responsibilities in terms of the role that the executive head should play vis-a-vis the role of the committee as it represents Parliament. A number of issues are obviously part of this. If you take the issues that relate to the demands, it does call for some administrative action. Now, whether or not we go in that route is not the matter. What matters is that that's one aspect of the discussion. The other aspect that becomes a matter is that there are challenges that are arising out of the religious and linguistic communities that need attention, which is a CRL responsibility for which the Commission needs to report to Parliament. And then there are also issues of possibilities of either regulations or legislation or some such policy considerations that might arise out of this process. So it would be important that when we start at that point with a good understanding between the committee and the minister. So that was really the main issue that made us feel we needed to start at that point. Now, having said so, I'd like to check whether the members would rather ask the minister questions or comment on the presentation, or they would rather we invite the CRL Rights Commission to also come in. Obviously, because we've had a meeting with this CRL Commission, we would obviously restrict ourselves to specific issues and questions and comments that are coming from the members and what the Commission might want to table. But in terms of going forward, we did say that the commission would have to come back with the original issues, retable those issues that started the process, and also talk about how their processes have gone, as much as we've had a discussion. And also we need to then, see how we get to engage with the rest of the stakeholders. But for purposes of this meeting, it was just to seek the wisdom of the minister in how this matter would be handled. And I think as a committee, we just need to hear the minister out, what his views are, what he thinks could be done in the department. Then we can move it from there. So that would be the approach at this point. Honorable Van Zyl, you might want to come in just now.
Thank you. Chair, do you want to give the minister a spot, or is this for me?
Okay, let me see if the minister would want to make any comment, then you'll come in after that. Honorable the Minister.
Thank you very much, Chair. Maybe for now, Chair, one can listen from members of the portfolio and then strike to find a common ground as to how we go forward. Thanks, Chair.
That's good enough, Minister. We will get the members to comment and we'll come back thereafter. Honorable Van Zyl.
Thank you, Chairperson. Good evening once again to the members this evening, and to the Minister and Deputy Ministers if they are present, as well as the Chairperson of the CRL. So, Chairperson, with what Mr. 𝐃𝐨𝐽 has just told us, we all are very much aware that the CRL is a Chapter 9 institution. And what is even more clear from the presentation that he has just made is to say that Chapter 9 institutions cannot make any regulations. The parliamentary body that can make regulations is Parliament itself, obviously, as well as the Cabinet. So the CRL Commission has no constitutional or legislative authority to be making any binding regulations over religious institutions. So there is a bottom line, and I think we need to keep that in mind as we go on and listen to what they have to say again. And I think after you have decided if they need to present, then I will make further comments. But I think very key from what this comment, this presentation from Mr. 𝐷ePofa has just told us, is that the Chapter 9 institution cannot make any, it's unconstitutional, they cannot make any regulations. Thank you, Chair.
Thank you very much, Honorable Van Zyl. Honorable Mkhaliphi.
No, thanks very much, Chairperson. I think from the word go, Chair, we must also state that as a committee, we wanted to include the minister, knowing very well that the minister does not have powers, especially on the demands from the sector that also matched, and the chair of the portfolio committee go and get the memorandum. We know very much that the minister does not have those powers that is included in the memorandum. One of them is to get rid of the chairperson of the commission. We know very well, Chair, that the commission is accountable here in this committee. I think the bone of contention, and I just also have to mention that I like your approach in order for all of us, including the minister, to have a say, because the issue here is also involves all of us in South Africa, as you alluded when you were giving the background, Chair. So the bone of contention is that when they were confronted by the sector, the defenders of Christianity, if I'm not sure if I'm pronouncing them very well, Chair, was that in terms of Section 22 committee, Minister, they have not included everyone. So they were isolated, and then they were criticizing the processes and procedures that were followed by the CRL. But the justification or the defense from the commission itself was to say that we are implementing the recommendations from the portfolio committee. So that's where we must start, Chair, in order to address this matter. And then we come back and said, no, there's a letter that the Chair also mentioned that was also addressed in one of the people who were challenging this process of Section 22 committee, to say that the Speaker wrote back to them to say there's no decision from Parliament. So there was a report that was tabled on the last day of the day when I think it's 2018, if I'm not mistaken. But that recommendation remained not a decision of Parliament because it was not processed in Parliament. So therefore, in order for the committee to take a decision whether the Commission is on the right track in terms of establishing Section 22, that is a bone of contention from the other sectors, or is not, we wanted to get everyone on the board to say, this is our understanding, all of us, that there is no decision from Parliament. Therefore, as a committee, we must start all over again, because we must. The Commission can't continue to say is implementing the recommendation from the community. We also mindful of the fact that this is not the committee they're talking about, but they're talking about the Committee of Parliament as an institutional memory. But when the Speaker clarified the matter recently to say there is no decision, that's where we must start to try to resolve the matter. In fact, Chair and the Minister, as we are here, all of us want a resolution to these issues. I'm sure the Commission wants to also to have a way forward. After we had a summit in 2020 in Parliament, including the portfolio committee that was in Parliament in 2019, we called everyone under one roof and said it can't be as business as usual, because at the end of the day, we must protect South Africans. We must protect vulnerable people who are experiencing petrol, cockroaches, and all sort of manners. So therefore, it can't be business as usual. So therefore, we must do something. So we are caught in catch-22 situation as the committee to say, we as a committee as well, we have to defend the poorest of the poor. And the Commission is saying, we are implementing your recommendation, whether it's 2020 after the summit, or based on the recommendation that was done in 2018, of which it gave us a problem when the Speaker said, no, that report was not a decision of the Parliament. That's where we must start, Chair. But again, let me use this opportunity as well, Chair, to find out from the Minister, because all of us in this committee, we also learn from the media that there's a new commissioners of the commission. We're not involved. Maybe for the sake of transparency, maybe if the minister can also cover that aspect to why the committee, although I know by law, we are not supposed to be part, or there's nothing force the procedure and processes of appointing commissioners. But since the commissioners are also accountable to this committee, why it was not transparent enough also the committee to be part and parcel of the process of appointing them. I know at the end of the day, Minister, it's not you, but it's the President. But for the purpose of transparency, it will be also going to be like balanced act to know that there are going to be a new commissioners, because the previous commissioners, their term of office has come to an end, or so forth. Thanks, Chair.
Thank you very much, Honorable Mkhaliphi. I don't see another hand. Can I ask the Minister if you would like to react to these comments, and then I'd ask the chairperson of the CRL Commission if they would like to make any comments, and then we'll try and see if we can synthesize a way forward. Honorable Minister.
Thank you very much, Honorable Chair, and thank you very much, Honorable Mkhaliphi, for that request for clarity. In terms of the process, the appointment of the commissioners were processed accordingly up to a stage where we forwarded to the President, who finally made the appointment. There is no step that we did not do. I may not be sure which transparency might it be referred to, because it was done openly, even when they have been appointed, the names were properly announced following the process of doing it. Only when probably we can be highlighted that there is a step which we should have done, which we did not do, then it can be a different matter. But in terms of the process, everything was done as it is required to a final stage, and eventually formally communicated through proper channels that here are the new commissioners of the commission after the President had appointed them. But I do agree, Chair, that we need to find a common ground on this matter, because it all affects us as people of South Africa, the commissioners themselves, the ministry, the portfolio, everybody. We need to find a common ground. Thanks, Chair.
Thank you very much, Honorable Minister. May I, firstly, let me request that if there is a challenge and I fall off, I seem to have had a weak connectivity this side. If there's any challenge, I'm going to request that Honorable Mkhaliphi, just to help steer the meeting through. But let me suggest a few things as follows. Thanks, Minister, for your explanation and your responses. Before we get the CRL Commission, because I think we're trying to pull this process through, I'd like us to approach it this way. Firstly, let us recognize the fact that there were issues that were community concerns over which the first outcry was about the abuse of the rights of the people in relation to the way some of the religious activities were being conducted. And that is one issue, but there were also criminal activities which are involved at that level. Now, that we need to then also recognize the fact that there was a discussion which ultimately was tabled to the portfolio committee, and because of the timing of the parliamentary of the last administration, this lapsed, and therefore the process cannot have any standing in Parliament since it was started at that point, unless it is introduced into the committee again so that it can be taken forward. That I think, therefore, based on that, we should then appeal to the CRL not to proceed with the Section 22 process, but rather get the issue restarted at the committee level, which means resubmit the issues that caused the outcry, community outcry, then reintroduce the approaches that were taken at that point, at the time that this matter was addressed, and with all the report of what was done, including also the details of the stakeholders who got involved in this process. Then, after that engagement with the committee, we then as committee need to approach those two groups. There's a group of religious leaders that have raised objections. There's a group that seems to have been involved and was participating and supported the process. Once we have had all of these views, we probably then will be in a better position to formulate a way forward that might then result either in the continuation or the resumption of that Section 22 committee process or its termination, depending on what we have to do. It may then further result in whether there's need for policy review in whatever form, whether it's a policy review in terms of white paper or policy review in terms of the legislation, so that those issues will have to be a product of that a process. If we take it that way, we are then in a position then to say we are taking everyone on board along as what the process should have been in the past, and then we also are ensuring that whatever processes had been taken into account in the past and are now would have now lapsed is then back on the table, and then we will then look at whether there's a way of resolving the differences so that everybody participate and cooperate in the process of addressing the original challenges. Because the questions right now is, I don't think the question is whether there were transgressions by various religious leaders. I think the question is on how to deal with them, what structure should deal with them, and whether in fact the current Section 22 process is itself in violation of the rights to freedom of religion and worship. And therefore, that process is something that needs to be mediated through the committee platform, and then we can then see whether we can get a way forward. So that is the proposal that we wanted to make, and I want to see if the CRL might want to comment, the minister might want to comment, so that we can bring the process back to the committee. And I would like a situation where even the minister and the department are very close to the process, to the extent to which the roles allow us to be able to make sure that there is an understanding for both sides as to what is happening. Then we don't end up with something that's going to fall in between the executive and the National Assembly processes. That is how I'm looking at it. I think from the point of view of the committee, that is how we thought we need to take the matter forward. Can I therefore ask CRL if you want to comment, and then the minister to comment, and the members can indicate if they think that there's anything else that needs to be put together, and then we can try and round up the meeting. Honorable, let's get the chairperson of the CRL Commission. Ma'am Taluva.
Good afternoon to the Honorable Chairperson Honorable Minister, honorable members, the DG, and the people who are part of this platform. I think as the CRL Rights Commission, we should start with one issue that we received court papers, High Court papers, about the Section 22 committee. We've been told by our lawyers that the matter is sub judice. We also received papers on the 20th that informed us that the South African church defenders, who are the applicants in this matter, are rejecting any form of mediation, whether it's organized by the court or whether it's organized by ourselves or whomsoever. We find ourselves in a very difficult situation because the matter is sub judice with also a firm request that any form of they object to any referral of this matter to mediation, whether voluntary or court directed. And they give reasons to that matter. One of the reasons that they give, part of the papers, is that the applicant has already taken extensive steps to resolve the dispute without recourse to litigation, including receiving no response whatsoever from Parliament or the relevant state organs. We are told that we need to abide by that court process. Be that as it may, I would like to respond to things that are new. For instance, the issue of the white paper. The CRL Commission doesn't know anything about any white paper because we feel it's not our role to be designing white papers. The Commission has not seen any white paper and has not approved any white paper, Honorable Chairperson, honorable members, honorable Minister, and the DG. We are awaiting the meeting that is supposed to be longer than the 30 minutes we were given before, because this is a very complicated matter that started way back around 2012 or so. So we appreciate that there are historical issues, but we also wish to highlight that when we received the decision of the Portfolio Committee in 2018, together with the religious sector, we then convened the NCC that is spoken of early in 2019, February in 2019. And there were recommendations made in that 2019 NCC which impact on the discussions today. The Act, the CRL Act, says we have to implement the decisions, the recommendations from the NCC, which we convened, and it consisted of cultural, religious, and linguistic communities, as was decided. Of course, we were not privy to what was happening in Parliament. We were not part of that process. So the sector, the community councils, and everyone who attended the NCC, when we said this NCC is to decide on this matter, and decisions were taken. And we think maybe we should be looking at that and looking at where we are as the CRL Rights Commission according to our Act, whether we're outside our Act and our constitutional obligations. Because we stand with the Constitution, We stand with the fact that there's an urgent crisis in this country that needs to be attended to. Be that as it may, we are saying we will hear what Parliament is saying, but that we object the disinformation that is being spewed out there. We might not have the resources or the means to dispute each and every one, but as the CRL Rights Commission, we welcome the High Court action that has been filed by the South African church defenders, because then the courts will be in a space where the court can then decide what is factual and what is not factual. You've given me just 10 minutes, Chair, but within that 10 minutes, we want to reaffirm our commitment as the CRL Rights Commission to Section 31 of the Constitution, which affords everyone the right to enjoy their culture, to practice their religion, and use their language. However, there's a rider in this Constitution, this section, that says that these rights may not be exercised in a manner inconsistent with any provisions in the Bill of Rights. For instance, Section 10, which talks to human dignity, and Section 11, which talks to right to life. We are within the act of the CRL Commission in the establishment of the Section 22 Committee, which will then at this point be decided by the courts, really, whether we're outside our mandate or not. We're also committed to Section 15, and we've always respected the Constitution. I don't know where this puts the process in terms of the court papers that we received and the refusal to mediation. From us, Honorable Chairperson, honorable members, I think we will stop there.
Thank you very much, Chairperson. Ma'am 𝐬𝐮𝐬𝐫𝐢𝐛𝐬𝐜, thank you very much. We did not intend that this discussion today would be elaborate on all the details of the matters involved. I think your comments for purposes of what we have convened for are adequate. Although I think as a committee we probably need to get a better sense of understanding as to from your legal advice, does that mean you would not then be participating in a process that this committee is contemplating on the basis that there is already a court application in this matter? I'd like you to clarify that aspect. Insofar as we as committee would be concerned, we would obviously, this matter of the court application came after we had raised these matters with the applicants before they actually, at that time, they were basically stakeholders were objecting. And so we started the discussion on the basis of the public comments, public objections that they had raised. Now, we would obviously get a legal opinion from Parliament on this matter, although I'm more inclined to saying up until there is anything that indicates that this matter cannot be handled by the committee, it was in the committee. I have not looked at the discussion, at the details of the court application. However, I have not seen I just skimmed through it. I didn't see anything that is interdicting the Portfolio Committee of Parliament from discussing or managing or engaging on this matter. So I would want us to look at that. So the question therefore is, should we expect any cooperation from the CRL Rights Commission when we get involved in this matter, or is your instruction from your legal team that you will not participate until this matter is sorted out in court? I just want to get that clarification.
Thank you, Honorable Chairperson, honorable members. As the CRL Rights Commission, we just got an indication from our lawyers that this could be a problem, but they've not given us a full legal opinion on the matter. And as the Honorable Chairperson says, the Portfolio Committee is still going to talk to your legal people. We got these papers quite recently, especially the one where they insist they do not want any mediation on the matter, and they want the court to be the final arbiters on the matter. We are consulting lawyers on Monday. We have a meeting with the lawyers on Monday where they'll advise us. But as the CRL Rights Commission, we have not taken any decision that says we will not participate in any process set up by the Portfolio Committee. We are committed to participate in all processes set up by the Portfolio Committee, and also the meetings with the Department of CoGTA and the Minister of CoGTA.
Okay, thank you very much. I think from where we sit as a committee, firstly, we have an issue on the agenda, which we are processing, which involves the CRL Commission, which involves the various bodies that have raised the memorandum. We have a memorandum that was written to Parliament, which we've got a responsibility to address, on the basis of which we have indicated to those who sent the memorandum that we shall be engaging with them and also other stakeholders in this regard. We would then, having been aware that there's a court application, we will get our legal team to look into that matter. As I've said, nothing short of a direct interdict that would stop us from taking the matter forward, and therefore it would be for us important to be able to indicate that as our approach, so that when we approach this matter and invite the CRL Rights Commission onto the meeting, we would obviously be expecting that cooperation, unless there is a contrary view that is actually given to us by the parliamentary legal team. That is how I would like us to look at the matter. Then on the other hand, may I invite Minister, if you would wish to comment on everything that's just been discussed?
Honorable Chair, in the interest of your concluding statement following the remarks by the chairperson of the commission, probably, Chair, because we all have a collective responsibility of finding a common ground. Now, the commission, as it is going to meet its lawyers and get a proper view, probably both ourselves and the portfolio, we bounce back to the legal aspect to give us a proper guidance on this matter. And then we can reconvene in order to find a way forward, all having been advised legally on matters that have legal implications. We will be open to engage and be advised accordingly as to how best we can find a way forward. That would be my contribution, Chair.
Thank you very much. Honorable members, I'd like you to comment if you would then support the approach. The approach we will take, firstly, is having noted the submission of the Minister and the comments from the CRL Rights Commission. One, that the Portfolio Committee will engage on this matter and invite the CRL Rights Commission to table the documents as previously requested. One, that give us a background onto this matter. Two, the report in terms of how the matter was approached. And thirdly, any comments or any commentary that relates to the current objections that have been raised, that those matters will be tabled to the Portfolio Committee at the time that will be convenient to the committee and the CRL Rights Commission.
Recording
Secondly,
stopped.
the Minister and Department will be involved and be closely liaising with the Portfolio Committee to indicate their concerns, to indicate their views as the processes are going forward. Thirdly, that the Portfolio Committee will, in the process, seek a legal opinion from the legal Department of Parliament onto the implications of this particular this particular court application, and that matter will also be tabled in the Portfolio Committee, so that the committee will then have a full view of all the issues and whether, in fact, there is in any way a restriction of the processes that the committee is involved in. And that, of course, that the different stakeholders would have to be involved, engaged by the Commission in relation to those who had supported and those who objected to the process. That unless there is a firm, obviously the question of the legal opinion has got to do with the fact that not only do we need to know what the implications are, but we also need to look at who else has to be represented in the processes of this matter being addressed in court. So that we will discuss again with the legal team in terms of what the implications are of the appearance in court. So all of that will be what we need to look at as the committee, and therefore from where we sit, we then need to get a sense of other members wishing to suggest any other amendment in the approach. Let's start with Honorable Van Zyl.
Thank you, Chairperson. Chairperson, I just want to maybe guide and say that I don't think we should proceed and do anything else that you have mentioned as a proposal before we get the legal opinion. I think we need to start there first. So, Chairperson, my proposal would be for us to get the legal opinion first and then discuss the steps going from there, because at this stage, we don't have any legal opinion to guide us as parliamentarians. Thank you.
Honorable 𝐬𝐮𝐬𝐫𝐞.
Thank you very much, Chair. Good evening. I just want to support Honorable Van Zyl in that and say I think we should first seek the legal opinion, because if we engage with the CRL, or for that matter any other person or organization that can have influence on the court case, we might find ourselves in a conflict of interest. So I think the legal opinion is very important, and therefore my proposal would be that we seek that first before we continue. Thank you, sir.
Thank you very much, Honorable 𝐬𝐿𝐫𝐿𝐫.
Yeah, Chair, plus the Speaker's office as the letter dated recently, 2025, when the Speaker clarified the matter in terms of the letter that she received from the, I don't know, is a defender of the church or the people that march as well, Chair. So I think it's very important as we outline the process that if this report was not decided by the Parliament as the Speaker's understanding, we need also to get that perspective from the Speaker. But I agree with all what you have mentioned, including the two members who said let us also get a legal opinion, because we are hearing for the first time that this matter has been taken to court. And I don't think when they were marching, the sector that marched that day mentioned to you when they handed over the memorandum to you that they've even taken the matter to court, or is a different group? I don't know, Chair. But I think that let us move as you propose, Chair, including the legal opinion, so we can have a way forward in this matter. Chair, can I also come back on the response of the Minister regard to the appointments of the commissioners? I was not fighting, Minister. I was saying, if you listen to the Chair as well, the DG also in his presentation said the Minister does not have anything to do with the work of the Commissioner, or with the work of the Commission. But the Chair is saying, in order for us to move together, let us involve the Minister. Whether in terms of the Act, there's nothing that the Minister gets involved with, but for the sake of the spirit of working together, I think let us have one understanding. So I was asking regards to the appointment of the commission in that spirit, that it can be that the committee also learn from the media in January that there are new commissioners. I'm not saying there were steps that were not followed, but I'm saying in terms of the transparency and in terms of the working together as a spirit that's supposed to be positive to all of us, because we were shocked. I think I also did it. I think there was something that was shared in social media about the commission. I can't remember what was the issue. And I also tempted to respond in Twitter or somewhere to say, but this is not true. This is not the chair of the commission. Because the last time it was, I can't remember if it was Dr. Masemula, it was Dr. Who. Until I went and researched, I said, there's a new commissioners that has been appointed. But as a committee, I mean, we're not even taken into consideration. I mean, just to be briefed to say, listen, the old commissioners' terms of office has come to an end. Now we follow all the necessary steps and we are going to have a new commissioners come January. So I was saying in that context, Minister, but I was not maybe accusing you or something. Thanks, Chair.
Thank you very much, Honorable Minister.
No, Honorable Chair, I just want to make it also clear to Honorable 𝐬𝐻𝐾𝐬. I took it in a good spirit, the question, and there was no element which even I felt is accusation. That is why I said, if you followed the procedure, but on the aspect of maybe letting the committee know if because the end of the term, we would presume that the portfolio will know because the commission is accountable to Parliament. Now, in terms of spirit, I got it right. There was no accusation. So that the Honorable 𝐬𝐻𝐾𝐬 also be in a good space. That from our side is that we thought we followed the process, but as a way of cooperation and even letting the portfolio know that there is this process, even if it is not prescribed. Well, it could be a matter that can be taken forward, taken into account going forward, but I didn't find any accusation, Honorable Chair.
Thank you very much, Honorable Minister. I think it's good to clear the air. But I think we're all agreeing that the close working together, it's important, and that at a certain point we'd like the Minister to give us an update report on the process of appointment. We might have missed it in the, might have lost time on the matter, but nevertheless it will be relevant that the Minister does that presentation. So we'll look forward to that in the next engagement. Honourable members, I think we are agreeing on the approach. Probably just change the sequence, from where how I put it, so that we need a legal opinion, and then after that we will then take those steps that I've indicated, provided there is no obstacle that stands on the way of those processes. But the fact that the matter would have cited probably just this, I'm not sure whether the committee is cited, but if the speaker is cited, of course, we are involved. So we will then be consulting the office of the speaker and then the legal opinion with regard to that issue. The reality is that there was no mention at the time of receiving the memorandum that this matter was going to court. It looks like it's something that actually was done a day or so after that, but nevertheless, we have to deal with the fact that there is a court application. But from where we sit, we've got a responsibility over this matter. So we'll get the legal opinion, and then we'll have to embark on the approach that we've indicated. But if there are problems arising as a result of the legal opinion, of course, we will not be able to proceed, as it were. So with that, I think we should then say it for the committee. We will then be informing the committee as soon as we are ready to table the legal opinion, and then, of course, look at the next steps forward. I hope that can be done even before we close, so that even if all the processes need to be done are not started this year, but at least we are clear which way we have to deal with this matter. We have already sent letters to the same members already indicating how we would like to take this matter forward. So those letters were sent on the basis of the fact that they'd approached the Speaker and Parliament on this matter, and it was not in response to the fact that they'd taken the matter to court. So we will then deal with it as members indicate. Legal opinion, then all those steps will follow. But if then there's the legal opinion precludes any further steps, of course we'll be able to determine that at that level. Honourable members, with that, I want to thank the Minister for your presentation and the department. I want to thank the CRL Rights Commission for your participation. Let me also thank the honourable members and all the staff that has assisted us in this process. At this point, I would like us to declare this meeting closed, and therefore would like to adjourn this meeting. And thank you very, very much, and have a lovely evening. Meeting. Let's push it up a bit. Thank you very much. Yes, the agenda is as follows. We have had the opening and welcome, but also we will take that issue further a little bit from now, but we will at some point therefore request the Minister will explain why we have asked for this meeting. And then, of course, after that, the CRL Commission will have a discussion, and then we'll take it from there. Let's proceed, therefore, from this agenda. It's a very specific meeting. May I then just give the background for Minister 𝐼𝐨𝐫𝐿, so that we are together before the presentation is done. From our portfolio committee, I hope that Shireen, you can share all the documents that we have received, so that all the members have got